a strange and quite frankly shocking decision, the Karnataka High Court on Thursday, 10th February, refused to grant any interim order protecting the rights of Muslim girls to attend classes while wearing their hijabs. Instead, the court has passed an order saying that educational institutes in Karnataka, which had been closed for the last couple of days by the Karnataka government, must reopen, and students to attend them must go without wearing any religious items of clothing or any garments, or even including headdresses or anything which has any religious significance, in the interests of tranquility and maintaining peace. Now, this decision does not mean the court has made a final finding on whether or not girls have a right to attend the classes wearing a hijab or a headscarf according to their faith. The main case will continue. It's going to be argued from Monday, 14th February onwards. The court will be looking at whether or not the wearing of a hijab is an essential religious practice for Muslim girls. To what extent can this be regulated? Should the state have any right to do so? And on that basis, will then pass a final adjudication on the matter. However, it had been requested to pass an interim order in the meanwhile, because this will take some time. It will take time to look at the issues and then deliver a judgment. The court had requested that during that time, it should instead pass an order allowing these girls to attend classes while wearing hijabs, while also wearing any prescribed uniforms, but wearing a hijab on top of that. Since this was something which these girls were saying was integral to their faith, was integral to their freedom of conscience, was integral to their dignity. And this is why the decision of the court is very strange and, as we said, quite frankly shocking. Because while this matter is going on, for the court to say that instead these girls must not wear their hijabs, must not wear their headscarves, as the Chief Justice of the Karnataka High Court, Ritu Rajavasti, put it, it's only a matter of a few days. What the court is saying is that for those few days, they are going to agree with the college institutions which have been trying to stop these girls from doing something which they believe is part of their faith, with the government which is doing that, and also with sort of right-wing groups and other right-wing Hindu groups and other miscreants around the state who have created a law and order situation out of this. It should be noted that the girls have at no point created a law and order problem. They are not the ones who have either been heckling other students or raising saffron flags at schools or creating a ruckus with stone pelting and other activities at any point of time. What the court has essentially done is they have essentially sided with the right of those who have been doing this so far, who have been trying to prevent these girls from being able to exercise and practice their own faith. It has come down, in a sense, in their favor and said that it is okay that till such time as we decide what you have done is fine, we are not going to stop you from doing that. And instead, these girls are being stopped from exercising something which they believe is very much part of their fundamental rights. Now, when it comes to passing of interim orders, there's normally a threefold test which is followed. There are three things which the court looks at. Is there a prima facie case for the order? Who is going to be, what is the balance of convenience in terms of who is going to be affected by it? And is there any party which is going to face an irreparable injury? In this case, the order passed by the court does not actually meet this test. There is no prima facie case to show that what these girls are doing is illegal. As has been pointed out before the court, not only is this constitutionally invalid, the Karnataka government, there is no Karnataka law which prevents girls from wearing a hijab, and even the Karnataka government order just passed over the weekend doesn't in its operative part say anything about the banning of headscarves. In fact, if we're looking at a prima facie case, the girls are the ones who have it, given that there is a Kerala High Court decision from 2016 which actually says that the wearing of a hijab is a part of the essential religious practice of women, of Muslim girls, and in fact allowed them to wear it while sitting for medical entrance exams that year. When we look at the balance of convenience, if the girls continue to wear their hijabs, that does not actually create any inconvenience for anyone else. Nobody else is being forced to suffer any violation of their rights. The schools are not being stopped from functioning. In fact, as was pointed out in Kamat's case, he's dealing with a case where a school which had for the last 2 years been perfectly fine with allowing these girls to wear hijabs, and only since 3rd February has now been stopping it. So therefore, the balance of convenience is also with the girls. And thirdly, when we're looking at the question of irreparable harm, while nobody is being harmed by the girls continuing to come to class wearing their hijabs. Instead, by not allowing them to do that, you are violating their right. As Devdutt Kamath pointed out, this is essentially a suspension of Article 25 for their rights. Senior Advocate Sanjay Hegde also said that this is essentially telling those girls that you don't have we are violating you for the next few days. It's a matter of a few days. During that time, you don't have your full right to practice your faith. That's why this decision is very strange. It's very shocking. It remains to be seen if this will be upheld. while the Karnataka High Court, as we said, is going to continue hearing the matter on merits, a petition had been filed in the Supreme Court by one of these girls as well. Chief Justice of India N.V. Ramana, the matter was mentioned before him on Thursday. He said, let the High Court take a decision first. Now that the court has made this very, very strange decision on the question of an interim order, it is possible that at least the Supreme Court may be asked to pass an interim order on the matter. And we will obviously be bringing you all the updates on that, everything which happens in the Karnataka High Court and outside the court, whether it's in the classrooms or in these the unrest which has been created in the state outside of it as well. So stay tuned to the Quint for all those updates.